Last week, the Supreme Court of British Columbia issued a ruling on the longest trial in Canadian history, which had to do with Indigenous land rights. Social media then exploded when people started covering the story. And although I don't use this word very often, all of it is
unmitigated horse pucky.
Let's just dive face first into this. Last week, Canada's longest trial ended, and it lasted for 6 years with over 500 trial days over those 6 years. Absolutely crazy long trial. And it ends in what they're calling a precedent-setting BC land claim ruling for four First Nations. So, this is what caused everything to explode on social media. And one of the problems is I don't think anybody actually read the ruling.
Except us.
Because there has been talk of civil war. There has been talk about people surrendering their homes. There's been talk about the Supreme Court stealing people's property. And it goes on and on and on and on and on and on. So, after taking a look at the ruling, which is what we've been doing for the last week.
Several days, yeah.
Because this ruling was over 600 pages long.
So I know that many of you emailed us to ask, why aren't you talking about this? Why aren't you talking about this? It took us time to get through this ruling. This document was huge. And we don't just base our analysis on what everybody's saying online. We want to go straight to the source. And in this case, the source is the judge's ruling.
Now, I saw somebody say, don't get cocky. I'm not getting cocky. I'm irritated. And why I'm irritated is because we're in another situation again where people are providing perspectives and providing opinions, and people are watching those opinions and trusting it as fact. And after looking at some of this stuff, my initial response is, you could not be more wrong. Like, literally, you could not be more wrong. And we're going to get into that. It's like if somebody told you that, a light was green when it was actually red. That's how wrong this is. So, and we always get a little touchy because we're protective of the audience and we're protective of the truth. And when something like this comes out and the due diligence isn't done, and you'll see in a minute what we mean by that, and it explodes all over social media and everyone is up in arms, and unfortunately now going after Indigenous people and the people that actually brought this case to bear, it's doing is causing more division in a country that's already more divided. So that's where we're coming from when it comes to this. So, as we go through, my request to everybody is pause your instinct to react, because we all will have an instinct to react to this until the end. And hopefully you will see exactly what we're talking about. Now, we're going to break this down so you know exactly what's going on, and we're going to pull out specific passages from the court ruling so you know what's going on, and the real problematic parts that completely blow up the narrative that's been going all over social media.
Now, before we continue, I just want to point out this comment by Laura Baker. It says, well, then perhaps the court should release a summary of the verdict for the media
They did.
and the peasants of Canada instead of a 600-page document that virtually no one will read.
Yeah, so at the top of the document is something called an executive summary. That's where it is. So we will provide the link to that ruling. Because you are right, Laura. If they just released a 600-page document, how can they expect the average person to go through it?
Even people who are journalists doing this for 8 hours a day for a full-time job don't necessarily have the time to read something that big. But that's what that executive summary is for. And that's why, I mean, again, we're not journalists, but we do take this very seriously, that we got access to this document, and then we made sure that not only did we read the executive summary, but we read a good chunk of that document as well, so that we knew exactly what's going on.
And the one thing I'll actually dovetail off of your point, Laura, is that I think this is low on the priority list for courts, I know, but it would be great if that executive summary was actually in plain language. Because even the executive summary, I will say, it's not obvious what happened. And in the ruling is written for the plaintiffs
lawyers, right?
and the lawyers. But it would be helpful for a case like this with such significance if there was a plain language section in here.
But this is why in a regular newsroom, you're going to have somebody whose job it's supposed to be to read these kinds of rulings, interpret it, and then write an article for the general audience. And it seems like a lot of that was missed, that people just went, well, I don't understand this, what's on social media, and then made their report based on that instead of actually doing the digging. And it's very important, if you are an influencer, if you're a reporter, if you're a journalist, that you do your due diligence and make sure that what you're reporting is correct.
So let's take a look. Okay, the entire case revolves around this. What is this? So this is a historical map, kind of laid over modern maps of a village from the Cowichan Nation, and this village is on Lulu Island, and it's kind of smack in the middle of Richmond, on the west coast of British Columbia and Vancouver. So it's a place called, and I'm going to butcher this, Tluk-Tinas. Something like that. Anyway, it's very hard to pronounce for me because I don't speak their language. Anyhow, what you see is a big green line that is circling the north part of the river and the north and west part of the actual image. This is the claim line. This is what the actual Indigenous people are claiming is the land that should be theirs and that they should have the title to. But the Crown does not, or did not, recognize that prior to this case. To make this a little easier to understand for those that actually know the area, went ahead and took a Google Maps image and overlaid that. So now you can see, you know, where the major landmarks are and where the major roads are, and hopefully that makes a bit more sense. Okay. This is the actual judgment that actually resulted from this case. What does this mean? So again, that green line is there for you to see what the initial claim was of the Indigenous people. And the orange and the pink areas are areas that were decided that this was actually what the Indigenous people were entitled to. Now, I'll start with the orange. The orange is Crown land that technically belongs to Richmond, and that was surrendered over to, or not surrendered, but declared as actually belonging to the Indigenous people. So the titles of those plots and those parcels of land belong to them. And that could be turned over immediately because there's nothing on it. There's absolutely nothing on it. It's just Crown land. It's not privately owned. It belongs to them. The pink area is a mix of private and Crown land. And that is a different story. This is where we get into where all of the misunderstandings of what was actually going on was. So that pink land, as I said, is a mix of hundreds of parcels of land that are privately owned in terms of residential as well as industrial. There's an Amazon warehouse in there. There's an IKEA building in there. So there you go. And when you actually unpack that, you begin to see that there's all this mix of Crown land that hasn't been sold to anybody yet and private land. Well, here, I'll come back to that reasoning. So moving on, why was this actually awarded? Why was the plaintiff successful in actually getting this land? So here's some extracts from the actual executive summary. So the Cowichan were an indigenous people comprised of 11 local groups prior to and at the time of European contact in the early 1790s. And at the time, the British Crown asserted sovereignty in British Columbia at 1846 and after. The members of the Cowichan tribes, as they are laid out there, and I will butcher their names there, that's where they are referred to as First Nations, are the descendants of the historic Cowichan people and the 11 local groups. As the modern day successor groups to the Cowichan as an indigenous people, the 4 plaintiff bands and the Liaxin are the proper rights holder for the Aboriginal rights and title in this case. Historically, the Cowichan occupied several winter villages on the east coast of Vancouver Island from what is now Cowichan Bay to the south as far north as Chemainus. They also had winter villages on the southern Gulf Islands, including Cooper Island, Thetis Island, Valdez Island, and Willie Island. Cowichan relied on fishing, gathering, and hunting for their food and traveled to various regions to exploit resources. So this is basically just saying, historically, this is what the plaintiff was actually able to show. And every summer, they travel en masse, etc., etc., etc. Plaintiffs have established Cowichan Aboriginal title to a portion of the claim area, so not all of it, but less than 50%, the Cowichan title lands. Prior to, at, and after 1846, the Cowichan sufficiently and exclusively occupied their permanent village, its surrounding lands, and the strip of submerged lands in front of the village at, well, the village I can't say. Now, here's some historical background. In 1853, Governor James Douglas told the Cowichan that the Queen had given him a special discharge or charge to treat them with justice and humanity so long as they remained at peace with the settlements. This was a solemn promise that engaged the honor of the Crown, and that means the Crown is supposed to abide by that, which is a constitutional principle that requires the Crown to act honorably in its dealings with the Indigenous peoples. In 1859 and 1860, Douglas appropriated, essentially meaning removed or set apart, Indian settlements from the Crown's land disposition processes, which includes sale and preemption. These settlements are set aside for the purpose of eventual Indian Reserve creations. At the time, the Cowichan continued to occupy this particular village and its surrounding lands. It was an Indian settlement, as colonial officials understood that term. Nonetheless, the Cowichan settlement was never established as an Indian reserve for the Cowichan. Instead, the lands were sold to settlers without the Cowichan's knowledge. Between 1871 and 1914, Crown grants of fee simple interest were issued over the whole of the claim area, including the Cowichan title lands. The first purchase of Cowichan title lands was made by Richard Moody, who was the first Chief Commissioner of Lands and Works for the colony of British Columbia and was tasked with ensuring that Indian reserves were created at sites of Indian settlements. Because occupied Indian settlements were appropriated and could not be sold, most of the Crown grants in the Cowichan title lands were made without statutory authority. British Columbia was admitted to Canada, as most of you know, on July 20th, 1871, under the BC Terms of Union. And it was to extend the appropriation of Indian settlements lands post-Confederation, limiting the province's ability to sell the land without first dealing with the Cowichan's interest. As a result, the post-Confederation Crown grants in the Cowichan title lands were made without constitutional authority because they were made under legislation that was constitutionally limited. The Crown grants of fee simple interest deprived the Cowichan of their village lands, severely impeded their ability to fish the south arm of the Fraser River, and are an unjustified infringement of the Aboriginal title. And at this point, this was something else that was all over social media. The judge declared later in the ruling, this is paragraph 3638, that she suspended the declaration for 18 months. What that means is she is not issuing that the lands are theirs immediately, but waiting for 18 months. During this 18-month period, the Cowichan, Canada, and Richmond will have the opportunity to make the necessary arrangements. Okay, let's pause there. So, what the judge found, and based on the executive summary, I agree with it. What the judge found is there actually wasn't a formal surrender of the land from the Cowichan to the Crown. And what it sounds like is that area was initially supposed to be marked as a reservation, but never was. And if it was marked as a reservation, none of that land would have been sold from the Crown.
To private interest.
Correct.
Right. Yeah.
But that ended up happening. So, and because that never ended up happening, any of the land sales that happened after that, the judge is saying, was technically unconstitutional. Now, this is where everybody assumes that the people that actually are landowners in this area are going to have their land stolen from them, which is 100% false. And they also read that 18-month timeline as in a year and a half, everyone with a home within that area and all the businesses in that area, they're going to be kicked off the land.
Which is not true.
Completely false. We're going to get into that too. Because if you read further in the ruling, there's one extra. This is probably one of the most important paragraphs in the entire ruling, folks. So what's been going around social media is that they're stealing everybody's land, and everyone's angry at the Cowichan for actually bringing this forward, and there's talk of civil war, and everyone should be afraid that they don't own anything, and there's all these implications.
Yeah, there's a lot of rage bait going around that if you own property in this area, if you have a business in this area, it's going to be taken away, etc., etc. None of that is true, and we will show you the ruling.
Paragraph 43. The balance of the lands in the claim that are not federal or Richmond lands are owned by private landowners who are not parties to this action. Third parties have fee simple estates in Cowichan title lands in sections. Off you go. Paragraph 44. For clarity, the plaintiffs seek a declaration that the fee simple titles held by Canada, the Vancouver Fraser Port Authority, and Richmond are defective and invalid because they say the Crown grants from which they derive were made without constitutional or statutory authority, and because the Crown grants of fee simple interest unjustifiably infringe their Aboriginal title. This is the most important line in almost the entire suit. They do not seek the same declaration in respect of privately owned lands or the YVR fuel project lands. What does that mean? That means, folks, that at the outset the plaintiffs, while issuing this claim on this broad region, are saying anyone that actually is a private landowner, we don't want to mess with.
Right. So say, for example, that Ryan and I own property in that area. We don't, but let's just pretend. They don't want to take our land. They don't want to do anything with that land. But we'll get to what they do want to do.
Yeah.
Just momentarily. Sorry, I don't mean to throw you off your game.
That's okay. I'm trying to remember where we are here. Just give me a second.
So this ruling doesn't mean that they are going to come in and take your land if you're a property owner in that area. It doesn't mean they're going to force you to shut down your business and rip down your structures or whatever if you own land in that area.
So here's a and this is from an article from one of the local news sources in the region prior to this ruling. Lake Cowichan Tribes Chief Seymour Sr. said in 2019 that the Quechan Nation was not seeking to recover any of the more than 200 privately held properties on the disputed lands in the court case. This is why we're annoyed, folks, because what was going around social media is that 137 people are going to lose their homes in 2 years, and the government's going to come and kick you off your land, and the Amazon warehouse is going to be shut down, and all those jobs are going to be all of it is literally false. Completely false. So what usually happens in these cases? A lot of people are still telling me I'm wrong. That's fine. That's fine. We're all entitled to our opinion.
Right, but our opinion is based on evidence, and this is the evidence in the ruling and the evidence based on precedent, which we're going to get into now.
So here's something that happened back in 2018. So this isn't really the first time something like this has happened. So this is a ruling that happened in 2018. Canada and Ontario advanced reconciliation with historic apologies to the 7 Williams Treaties First Nations communities. And basically what happened here is there was a dispute where there was a bunch of land that should have actually been or remained in First Nations title holding over this whole time, but it wasn't. Same thing, it was gobbled up by the Crown at one point, and they wanted it back. So what happens in these cases? Well, what happens in these cases is the government will essentially give back the land, and in many cases, the government will essentially properly buy the land that they want to keep from the First Nations people. That way, the land is finally properly transferred, and everybody's happy.
And what happens in the case of a third-party property owner? Again, use the example if Ryan and I had property out there. Well, what would happen is, say we owned an acre of land. The government would say, okay, well, that acre of land is worth, say, $100. So we're going to give the First Nations $100 of government money. Remember, government doesn't have money. Government has taxpayer dollars. So that's where this becomes a bit of a problem, is that now the court ruling has suggested that the parties, so the government, the Crown, and the Indigenous community have to negotiate, what is an acre of land worth? How many acres did you sell, 100 years ago to private investors that now you have to pay us for? And this is where it gets a little sticky, because this is taxpayer money that the government is now spending to fulfill this treaty.
So we're not saying we agree with the First Nations, Indigenous people. We're not saying we agree with the government. We're saying this is what the ruling was.
Well, and this is the impact to everyday Canadians. You're not going to lose your home if you have property in that area. You're not going to lose your business. But as a taxpayer, you are going to be paying money for that land. And those of us who don't live anywhere near it, we're going to be paying money for that land, because it's all taxpayers, right? It's government money.
Well, and there was also some other defendants in this, because there was some other tribes that have actual rights to fish in the river and things like that, and they're not happy that the Cowichan have been given the ability to actually fish there. And so there's some unhappy defendants there. I don't dispute that. That's fine. And they can appeal the ruling if they feel that that's correct. The main point here is that this was being touted as essentially the beginning of the end for land ownership in Canada, because the government was going to start kicking people off the land. And it's patently false. And it's never, ever happened in Canada. And there's no expectation that it's going to start.
Well, and the thing is, this isn't even precedent setting because of the case in Ontario.
Right. The main part that's precedent here, if you want to call it precedent, it's a bit of grandstanding in my opinion by the plaintiff's lawyer, is that it's technically the first time where a ruling was given on a claim on an area where there was specifically privately owned land. But it doesn't matter because that land is out of scope for the transfer anyway. So, which was very wise to do, in my opinion, because let's follow this through, folks. If everything that everybody was saying was going to happen actually was going to come to pass and people were going to be kicked off their land, that would be a huge, massive problem, and there would be legit outrage everywhere. And I mean everywhere.
Well, I mean, could you imagine you've paid however many hundreds of thousands of dollars for a home, and then the government, or I should say the courts, approve this case, or I don't know what you want to say, approve the case, but then all of a sudden your home is just gone. Yeah, like, hey, thanks for coming out. You know, all that money you sank into your home, it's gone. What happens to your mortgage? Who knows?
So legally, what would happen? Let's just say that is true. That's basically anyone with a private parcel of land there, they would be told, you don't get to have that anymore. What would happen legally is that the government would need to negotiate with the people on those parcels of land a fair market price for that and give them the money that they would actually get in the open market.
Right. Well, it's like when they want to build a highway or something. Actually, your aunt and uncle had this happen to them, where they were expanding the 407 and their home was bought by the provincial government.
It's the same type of thing.
Yeah.
Right? Same type of thing. So that's what would have happened. There wouldn't be a case, and there has never been a case, where the government would just kick you off the land. Like, they can't legally do that because of our laws. So that's essentially the crux of this. Okay. Does this mean that we should relax and think that the Liberal government is going to do everything fine? No. Does this mean that we should relax, or people in BC should relax and trust their NDP government and not bother to hold them to account? No. What this does mean is, when it comes to this particular case, a whole bunch of stuff that's been going on social media is actually false.
Don't believe the hype.
So that's what that means. And if people want to disagree with the facts, you have the right to do that. You have the ability to do that. So that's fine. This is our job, is to give you the facts and to give you our opinion. We haven't really given much opinion today. It's been primarily factual, and what is in the ruling, and what that means, and what that means for Canadians, and what that means for the people here. I anticipate this court battle to continue, and it may be the longest running case in Canadian history, because there's probably going to be appeals. I don't know. But the people that are the private owners of the land there have zero to worry about. They're completely out of scope when it comes to this ruling and the declaration of what is and is not Indigenous land.